So this witness in this court, he is Colonel, and I'm not saying this facetiously, he is addressed as Colonel Steyn. When he gave evidence in this court, he was referred to as Colonel Steyn. When House gave evidence, he was also referred to as a Lieutenant Colonel. That's what the law says. And this is categorized under what they call courtesy, the requirements of courtesy. In HIMSRA, page 166. The question may never go outside the bounds of, the questioner may never go outside the bounds of decency. Where the limits may differ from one witness to the next, but courtesy is always expected from an officer of the court, like advocates, even the judge. Furthermore, courtesy costs nothing, and practitioners owe it to the court and every witness. You can see the case of S versus Azau, 1974, 1 SA 808, Transvaal, at page 810G. The dignity of a witness may never be ridiculed. See in this respect S versus Tswai, 1988, 1 SA 851, Cape. The courts warned against the tendency of cross-examiners to sneak in personal opinions on the witness's credibility, including crude variations such as, "Now you are lying." Not only is behaving in an insulting manner towards a witness an abuse of the right of cross-examination, it is also a contemptuous assumption of the court's function as sole arbiter of credibility. The cross-examiner should never tell a witness that he or she will argue at the end of the case that the witness' answer should be rejected for the reason explained to the witness in putting the question. Everyone is entitled to be addressed by his or her surname and title in court. The use of forms of address such as witness, accused, etc. are disapproved of. You can see this, the case of S versus Gwebu, 1988, 4 SA 155. And also the case of S. Gulake, 1991 SACR 101A at 103F. It is simply not acceptable to address an adult by his or her first name. In Tswai, the court pointed out that especially the humble amongst us should be treated with respect and understanding, with respect and correctly and timeously admonition or timely admonition. Fairness. The cross-examiner may never exceed the limit of fairness. This applies to all cross-examination. Even the prosecutor is admonished that he should guard against excesses, particularly when an accused is not legally represented. In the case of S versus Ntshoni, 1987, 2 SA 671, Orange Free State, unfair cross-examination of some accused affected the fairness of the trial and the other accused to such an extent that several convictions were set aside in review. In S versus Nkabinde, 1989, 2 SA 421, a conviction was set aside because of, inter alia, the irregular manner in which the accused was intimidated, insulted, ridiculed, belittled, and confused in cross-examination. The failure by the magistrate, even the failure by this judge, to stop the unfair cross-examination was found to be fatally irregular. In Ntsani, it was also stressed that a presiding officer should repeatedly, if need be, stop unfair questioning or statements to witnesses that a presiding officer finds inappropriate. And it was also stressed that the presiding officer should repeatedly, if need be, stop unfair questions or statements to witnesses. Unfairness, of course, does not only mean the type of violations mentioned above. Inaccurate statements, for instance, concerning the other witness, are also unfair. What is more, muddled the search for truth. That's what they do. Elaborate, vaguely formulated, two or more multifaceted and argumentative questions perhaps cause heat but shed no light. Above all, such questions are unfair to the witness, especially when a person who uses the shotgun method of questioning, who is so keen to accuse the confused witness of evasion. Cross-examination is not meant to be a test of stamina. I once said this. See in this regard Africa Solar Pty Ltd, Diwadi Pty Ltd, 2002, 3 All South Africa SA 369. It's an SCA decision. Fairness also requires that the honor of a witness not be attacked in argument when there is no opportunity in cross-examination from him or her to react to such accusation. They quote the case of President of the Republic of South Africa and others versus South African Rugby Football Union and others, 1999-10. It's a Constitutional Court case, 2000 SA, at paragraph 61 to 63. And they also quote the case of S versus Buzak, 2003 SA 381 SCA, at page 51 to 54. Honesty. Obviously, the cross-examiner may never cross the limits of honesty. A witness may not be misled. No untrue statement may be made to a witness. Statements as to what other witnesses might have said must be accurate. If a cross-examiner is not certain whether an allegation by another witness has been correctly remembered or recorded, he may or she may not put it to the witness before clarifying same. Questions may not be formulated in such a manner that they appear to be statements of fact that witnesses made, where such so-called facts do not form part of the cross-examiner's case and will not be given in evidence. The other issues I'll go to inadmissible evidence. Cross-examination based on inadmissible evidence is not permitted. Examples of such inadmissible evidence are a confession which was excluded, for instance, as being inadmissible, etc. Inadmissible evidence may also not be introduced under the cloak of cross-examination. They quote the case of S versus Nkwanyana, 1978, 3 SA 404 Natal. And then they talk about principles under cross-examination. A trial is not a scientific experiment where certain reactions lead to exact results. It is a fallible process which attempts to form a view with reasonable confidence. Cross-examination, an aid in that process, employs several methods to test reliability of factual findings. One such method is to weigh the relative merits or different versions of fact against each other by bringing them into confrontation with each other. And they also talk about curtailment of cross-examination. And this is Himstra. General curtailment of cross-examination. It is a fact of life that protracted and apparently irrelevant cross-examination is a problem with which the presiding officers have to contend with. On the one hand, cross-examination is an indispensable component of the criminal process to advance reliable adjudication of facts which, for reasons of principles and pragmatism, is entrusted to the parties. In an accusatorial process, the parties decide which evidence to present to the adjudicator of facts, meaning the judge, whether in writing or orally or in cross-examination. This is their right and duty. They may have information at their disposal of which the presiding officer was not knowledgeable or has no knowledge of, which she would in all probabilities would otherwise never have had. The parties may have the aim with their questions about which the presiding officer knows nothing and does not need to know. To a large extent, therefore, the presiding officer has to depend on the parties regarding the presentation of evidence. Here they warn judges that the measure is not about boredom or impatience of the judicial officer, irrespective of how prolix and even apparently misplaced a cross-examination may test a judicial officer. Irrelevancies can always be ignored afterwards. On the other hand, one can only speculate about the possible importance of particulars which remain unhidden in the proffering of the evidence. It certainly does not mean that boundless cross-examination is allowed. Where the credibility of a witness clearly is not in issue, the question may certainly be asked that is intended, of what is intended. In the absence of convincing explanation, curtailment will be in order. Also, if the court is, after judicial consideration, considering granting the right to explain the purpose of the questioning, and is convinced that one or more of the factors mentioned in Cele are present, an appropriate absolute limit may be set. They repeat again that cross-examination is not meant to test stamina. Although the court can intervene against cross-examination, the only apparent purpose of which is to tire the accused or a witness, curtailing cross-examination which is intended to traverse again evidence which already given may constitute an irregularity. Like this witness. This witness was called here, as I proposed, in a circumscribed fashion. 3 issues he had to enunciate. I won't mention what other cross-examination he was taken through. This may be interpreted as amounting to the gagging of the defense. For instance, in S versus Ngogula, 1979, 1 S8 3525 in the Transkei. The conviction was set aside because the magistrate did not allow the accused to ask questions about something the latter had said in his evidence in chief. The trial court may, however, prevent unnecessary repetition. If you see, this case is S versus Green.